Hi, Kaitlin. All right, we'll get started. Welcome everyone to a holiday edition complimentary Franczek webinar. This is this is all the only gift we could give is our time and insights on Public Act 103-0473, which sounds like hopefully the worst Christmas or holiday gift you'll be getting this season. So, but that's what we have to offer. So here we are. Um, Kaitlin and I have been getting some questions as this new law is going to go into effect January 1st. So we want to make sure everyone understands what is in the new law and try to give some insights as you're thinking about how you might handle implementation. All right, with that, we dug into where did this law come from, why the change in the law. And this is an article from the sponsor's website that describes the purpose was to get more transparency for parents when their child is alternatively placed. And I firsthand observed parents being confused and frustrated. Obviously, if you get a call that your student's being suspended, expelled, those are horrible calls. And your role as an administrator is something like a dentist who has to tell someone their tooth is being pulled out or something. Those are hard conversations, and people aren't necessarily in a good place to listen and digest information that can be confusing about alternative placement. So I do understand her point that, transparency and clear communication at this time is important for parents. So maybe Kaitlin can help us see what the law did to try to accomplish that goal.
Yeah, so starting with what well, let's start with what Public Act 103-0473 did. I'm going to turn my space heater off so you can hear me, but I am freezing in here. So the governor approved this public act on August 4th. So it's been out there for a little while, but it doesn't actually take effect until January 1st. And what it does is it amends Article 13A of the Illinois School Code. What already exists in Article 13A is the section that says any student who is determined to be the subject of a suspension or expulsion in the matter provided by section 10-22.6, so that's our student discipline section of the school code that governs suspension and expulsions pursuant to your board policy, may be immediately transferred to an alternative school program. And typically our alternative school programs under Article 13A are our regional safe school programs. So those already existed under Article 13A, and this particular section on this slide remains unchanged. What did change, however, is this section that provides for more transparency, as Jennifer stated earlier. Now, before we make those transfers, we have to provide the student's parents or guardians very specific information about the alternative school program. And that specific information includes the specific nature of the curriculum used at that program, the number of students in the program, the services the program provides, what their disciplinary policies are, what the daily schedule looks like in that program, and what extracurricular services and activities are offered at that alternative school. Additionally, so that's what we have to provide before the effective date of the transfer. Once the transfer is effectuated, at the earliest time thereafter, we have to have a meeting with personnel from the sending school. So for those of you who are from school districts, from your school district, and then with personnel from the alternative school to meet together to develop an alternative educational plan for the student. And the student and their parents and guardians shall be invited to the meeting. Now, that doesn't guarantee that they'll attend or not, but they should at least be invited. So what goes into that alternative educational plan? Number one, we need to have a duration of the plan. I think that was one of the big pieces of transparency here, is sometimes parents didn't know, even though I think it was tried, there were always attempts to explain it, at least in the alternative placements I was involved in. Parents didn't always know, is my kid now going to alternative school forever? Will they never go back to the general education building? So in this written alternative educational plan, we need to include the duration of the plan and a specific date after which the student will be returned to the regular education program in the public school. The academic and behavioral components of the plan. So what is the student going to do academically and behaviorally at this alternative school? What are the expectations? And how are we going to review the student's progress? And what are the expectations for them transitioning back to the public school? And when are we going to have a transition meeting prior to that transition date that we've established? So 30 days prior to the transition date, we need to convene that transition meeting to make sure the student is ready for that transition. We also now can't extend the student's stay in the alternative program over the objection of the student's parents or guardian. So previously there was kind of an, I would say, an informal practice, maybe you disagree, Jennifer, but an informal practice of, well, you know, we said your student would be here for X number of years, but they're doing really well here, so we know it's kind of longer than that, but they're really making progress here. We're just going to keep them at the alternative school. And a parent would say, well, we don't want them to stay there. We'd say, well, but they're doing really well, so they're going to stay here. Now it's very clear that if the parent or guardian objects, we cannot extend the student's stay. However, if everybody agrees, there can be a written agreement to extend the student's stay. We may extend the student's stay by written agreement.
So, I mean, what I take from that, Kaitlin, is that our first date that we put in the plan should be the outside limit of how long you think the student might want to stay. You could always reduce it. You know, usually parents and students will agree to shorten it, but if there's a thought that the student's going to need to be there, don't have that date be aspirational and shorter than you really think is needed or required by the situation. You want to go with your longest date on the front end.
I agree.
Yeah. I should have told folks they can put questions in the Q&A if they have any as we go here.
So that is kind of the summary of what changed in Article 13A. So to just summarize, Article 13A are our alternative school disciplinary placements. So these are only used for students who are subject to suspension and expulsion, and who we are looking to place in an alternative school. They have to meet the criteria for suspension or expulsion, and we have to develop one of these alternative educational plans. Now, before we do effectuate this placement, we have to provide that information that was in the prior slide to the family. And after we effectuate the placement, we have to have the required meeting. There's a question about if the family leaves the district and does not show any evidence of attending the alternative school, can we have students serve that time? I think it would depend on what the board's decision is in the expulsion resolution. So it's going to ultimately depend on what the board decided.
Usually, oftentimes I'll recommend that the resolutions say that the alternative the alternative school offering, whether it's a 13A or something else, that it is available as long as the student meets behavioral, academic, and attendance requirements. So if the student is basically truant from that, and then if the student doesn't meet those requirements, then the student is basically completely expelled for the time period. So that, because otherwise, if you just do an alternative placement and then you're having behavior problems, I guess the safest thing would be to go back to the board and either expel or do a new discipline. But you could just embed it in your initial decision that if there's further behavior, further truancy at the alternative program, then the student's expelled.
But I guess I think the underlying issue is, so the part of the question is if this discipline incident, they were placed in an alternative school through June of 2022 and didn't attend. And then they tried to come and enroll now, which it's now December of 2023. Can we go and just enroll them in the alternative school now? My answer to that would be no.
Probably no.
Only expel for a period of 2 years. So they've served their term of expulsion or alternative school placement or whatever it was. So they now are subject to general education enrollment, just like anybody else, would be my answer to that.
Yeah.
Any other questions on 13A administrative transfers before we move into 13B placements?
I think we're good.
Okay. So Jennifer, do you want to talk about 13B placements, or do you want me to give a little summary?
Why don't you're doing great. Why don't you keep going, and then I'll jump in when we talk about, we're gonna, for people to know where we're going with this, there's so many different kinds of alternative placements. We're gonna try to synthesize it for you and figure out kind of who's on first for different situations.
Right. So 13B placements are another type of alternative placement, but these are not for students subject to suspension or expulsion. These are designed to serve students who are at risk of academic failure. So these are our alternative learning opportunity programs, or our ALOPs. These are for students who are, as I said, at risk of academic failure, and that is defined to mean a student at risk of not meeting the Illinois learning standards or not graduating from elementary or high school, and who demonstrates a need for educational support or social services beyond that provided by the regular school program. Such students are eligible for services up to the age of 21. And an ALOP shall provide a flexible, standards-based learning environment, innovative and varied instructional strategies, a student-centered curriculum, social program, and supplemental social, health, and support services to improve the educational achievement for students at risk of academic failure. So I don't know if we have anybody from the ROEs or intermediate service centers on our webinar today. I'm just looking at our participants, and I don't see any ISC participants, but I'm only scanning briefly here. Many of our ROEs, I know some of the local intermediate service centers have developed ALOPs in recent years, particularly some virtual ALOPs. So these are becoming even more popular than they were before, especially in our post-COVID era, where we have students who are just not returning to school. They don't want to go in person, and they really are meeting this criteria of not meeting the Illinois learning standards or graduating because they're not going to school. And we know that they need educational support and social services because we can't get them to school. So some of your ROEs and ISCs have done a really nice job developing these ALOPs. One thing I will note is, to be an ALOP, you have to meet specific criteria. So you can't just wake up one day and say, well, we've decided we want to be an ALOP and we're opening an ALOP. You do have to go through a process to become an ALOP pursuant to Article 13B. If you want to place a student in an ALOP, you have to develop what is called a student success plan. So as you'll recall, under 13A, we talked about that alternative educational program. This is kind of the Article 13B equivalent. So it's called a student success plan, and it's similar, but not exactly the same. In this student success plan, we have to define what curricular and instructional methods are going to be used to improve the student's educational performance, what support services we're going to provide that student to remove their barriers to learning, what career development experiences the student will receive to enhance their career awareness, any objectives that are needed to ensure career awareness, what school program or post-secondary educational options they'll receive, and what the student's responsibilities are under the plan. We also need to define the reasons that the school district referred the student to the ALOP, a determination of the student's needs and strengths, expected academic, social, and behavioral outcomes, the way we're going to assess if this plan is working, an estimate of the length of time the student will be in the ALOP, and a description of the parent and guardian commitments. This is almost like IEP light. So we need to have a defined plan. I think some of this is to, sorry, I'm just looking at the questions rolling in, which we will address, is to make sure we are not losing track of these students. There were times where I think a lot of students were placed in these programs and their home districts were just sort of losing track, not due to any malintent, but they were placed and we just lost track. So these are really making plans to make sure we know where these students are and we're keeping track of them. I want to go through some of these questions. Going back to a question from the previous section of families who were placed, it sounds like disciplinary placement and then refuse to attend the alternative school and then try and come back because they want to avoid the placement and not send their kid to school at all. I mean, I think we have to try to follow up with them during the term of that placement, but essentially they've served the expulsion if they haven't gone to school for those 2 years and then they come back to you. So we can't make them serve it again when they come back and enroll.
We got a question about, could you use an ALOP in lieu of a special ed program for a student with school refusal? That is a little bit risky from a special ed liability perspective. I would say there's not a lot of liability risk in terms of these ALOPs if you have clear evidence that the needs are not disability related. So if there's circumstantial or like COVID related, and we're sure that the school refusal is not disability related, then that's really the appropriate time for an ALOP. It's if disability is suspected, you would be in a much better legal position to do an evaluation and find the student not eligible, and then maybe an ALOP is a follow-up step to the student not being eligible. Or perhaps if a parent has revoked special education services, in that scenario, I would feel safe using an ALOP to address something that might otherwise be a special ed concern. But just in general, you will have liability risk on a special ed end if you use an ALOP when you suspect a disability need. Let's see. We got a question. Will this be sent to participants? We will post this and we'll have a recording and share this presentation. Happy holidays, our gift.
I think who needs to write the student success plans? I don't think it's entirely clear. I think it needs to, ultimately the school district is responsible for the student. So if anyone
come back to bite the school district as opposed to the serving school. So whoever writes it, I don't think it matters, but the school district should be a driver and holding the team accountable that there is one written. And really, you're the ones who knows the student going in. The receiving school doesn't have any of the background information. So it seems to me a lot of the information and logistics are going to come from the school district, not the receiving school. Maybe what the receiving school is contributing is more on the intervention, like what is being provided, as opposed to defining the student need.
Yeah, it's really going to be a partnership.
Yeah.
I did see a question, and hi, Anne. Does any of this change if the student is now a youth in care at one of our state orphanages? You know, the responsibility and who is the LEA may change, but it doesn't necessarily change the obligation to serve the student. And so there may be a residency question of, okay, who is the student's home district now, depending on who has responsibility for that student and how they became a youth in care. So this gets into some hairy residency issues of, did they get there through the foster care system? Did they get there through like Department of Juvenile Justice? What state orphanage they're in? So this raises a whole other webinar that we've done on residency cases, but it doesn't change the obligation to do a student success plan and or to do an alternative educational plan under 13A.
All right. I enjoy charts. Kaitlin and I struggled a little bit. I'm not sure we fully captured everything we wanted to say about unsorting the different kinds of alternative placements, but we gave it we tried. And this is where I think it's confusing. And Kaitlin and I even talked about, okay, this new law applies to 13A and those requirements. Should we be thinking about this issue of transparency and notice to parents about when the student comes back in other situations, and might there be confusion depending on which type of placement? So just as a reminder, we have the 13A, which we just talked about, the requirements, the 13B, which is the ALAP, and realistically, those are largely collaborative. So 13A is not always collaborative, because if you've fully gone through your suspension or expulsion due process procedures, then that is a district, I'm going to say, not a parent choice. You know, 13B, you would want to have more collaboration, I think, with the parent. Expulsion, just traditional expulsion, it's not in the parent's hands. They get due process, or the student's hands, decision. It's not their decision. We, the district, are saying you violated the code of conduct, and so you're not no longer able to go to the home school. Then there are IEP, and this is where I think it's the IEP interplay with all this that gets confusing. So for your special education students, there's 45-day interim alternative placements that could be for weapons, drugs, serious bodily injury. Again, that is actually not an IEP team decision. It's an administrative decision based on a student both having an IEP and engaging in one of the qualifying kinds of conduct, but it is limited to that 45-day window. Or we have also IEP changes of placement, which the parent gets the notice and the transparency through the IEP process, and either and basically just doesn't file due process, or if it's done at a meeting where an MDR is done, the parent actually agrees. So there's different levels through this chart of who's the decider of whether the student is going to the alternative school or the home school. And let's go to the next slide, because this is where I think it gets even more complicated, is abeyance agreements, which if you work with Kaitlin and I, you know, sometimes these can take many different forms too. And they could be for any type of, you know, we could do an abeyance agreement is usually an agreement, and it could be before or after a discipline decision. So it can be when a discipline decision is recommended, and basically the administration agrees, we're not going to pursue that. We'll take a pause and not pursue exclusionary discipline if you parent agree to some interventions, usually an alternative placement. So that is usually the overview of what is in an abeyance agreement. That is sometimes done before an expulsion. Sometimes it's done after, or the board makes the decision. This is what I was kind of referencing before, where they decide to expel, but say we'll hold that decision in abeyance as long as the student attends alternative school and meets certain requirements. The abeyance agreement may provide for a type of placement on the other page, including an IEP placement or a 13A placement. So it could be the abeyance, the alternative placement is one on our chart on the other side, or Kaitlin and I were talking about, in settlement agreements, you can work with the parents and kind of agree to anything and waive legal rights, as long as it's basically not unconscionable, like there's a limit to what you can do. But in general, you might come up with the parents some other type of alternative placement that's not contemplated by any of those laws on the chart. So, it could be some modified homebound thing. It could be a private, the parent decides to privately place and fund. It could be a homebound placement. It could be a private school placement, not one of the ROE safe schools. I can think of a lot of situational alternatives that come up through abeyance agreements. Now, in our opinion, the 13A requirements don't strictly apply to all of those negotiated outcomes. But it's not a bad idea. And so consider, Kaitlin and I are considering right now the abeyance agreements that we recommend, and if there's any information we want to add to the same goal that the this legislator had of parent transparency and clarity on what decision is being made through those abeyance agreements. In the past, I've certainly tried to be very clear to parents on what they are agreeing to or not agreeing to, but this is a reminder that there's a perspective out there that that's not always being accomplished. So I don't know, Kaitlin, what do you think?
Yeah, I certainly think it's a best practice. You certainly want anybody entering into an agreement, whether required or not, to know what they're entering into. You never want to be on the other side of an agreement where someone says, well, I didn't know what I was buying. So I don't think it's a bad idea to have those even when they're not required. And that gets to one of the questions that just came into the chat: is everything that is required for 13A also required for 13B? Jennifer, tell me if you disagree. I don't think all of those formal notice requirements on the curriculum and the services and the extracurriculars and all of those are technically required for 13B, for the ALOP.
I agree.
But there's no reason that you can't provide that information to parents in advance of placing in an ALOP. And there's, in my opinion, no reason not to. Certainly if they ask for it, sure. And most of the ALOPs have at least a brochure or a website or something. So it's relatively easy to provide that information. Jennifer, I'm curious your thoughts on this question. I have some thoughts on it. If your school district has its own alternative program for discipline housed within the district's boundaries, do these new requirements apply? And some of it, I think, will depend on, is your alternative program anonymous attendee? Is it a program that is operating under Article 13A? Because that is a very specific program under the school code that's operates under 13A.
Right. That's exactly what I was thinking. I am aware of and support schools with a variety of, I'm going to say, setups for alternative programs, and they look different, and I don't think they all operate under 13A. So this is definitely our attorney answer of it depends. It will give a solid "it depends," which may not give complete clarity. But with that, we're at our time. Thank you all for joining us. We hope that this was helpful in at least understanding the new what's coming January 1st, and happy holidays to everyone. Thank you.
Bye, everybody.